Welcome to Legal Consolidated Barristers and Solicitors. My name is Professor Brett Davies, and today we're going to be building a self-managed super fund binding death benefit nomination non-lapsing. What a mouthful. So before we start building this particular document for your self-managed super fund, let's have a look at what happens to your super when you die. Now, there's an article written, there's the address for it. So when you die, your super can only go to one of two places. It either goes into your will, called the legal personal representative, so it either goes into your will or goes to a dependent for superannuation purposes. What's a dependent? Well, a dependent is a certain type of person, such as a spouse or a child. If you don't have any of those dependents, then you've got no option. The super must go into your will, which is you tick the box, legal personal representative. Now, people are unaware that there are three ways in which to move super. There's three things that control super. The first is the trust deed itself. Now, whether you're an industry super fund or retail super fund or a self-managed super fund, which is what we're discussing today, a trustee can control where your death benefit goes to. This is what happens after you die. Or the trustee's discretion if you don't do anything. Or you can have a nomination, such as a binding nomination, which is the document we're going to draft today, which will force against the trustee where you want your super to go. It will force the person, whoever's running the self-managed super fund, to force the money to go to that particular individual. Let's say it's your will. Now, Mum and Dad told you that superannuation was a tax haven, and it's true. However, there is up to 32% tax on your super when you die. Oh no, Professor Davies, that can't be true. It's a tax haven. I'm telling you, I'll say it for the second time, up to 32% of your superannuation can be lost when it goes to adults, such as adult children. Not your spouse, but to adult children, or to family or friends. That's a big issue. Now, if you do want to learn more about that, type into your internet browser. Let's have a look here. 32% tax on superannuation, and there it is. Have a look at Legal Consolidated's website, which goes through how the rules are worked out and how you can get rid of that 32% tax on your super when you die through a 3-generation testamentary trust. But that's not for today. Today, I want to make sure that upon your death, your super will go into your will or to the people you want it to go to. What else have we got here? There's a non-binding nomination. I don't know why you do that, because it's not binding, so the trustee keeps discretion. But it's part of the package you can get when you build this particular document if you want to have a non-binding or a binding. There are a number of court cases, and I think one of the most important thing is this here. Your superannuation fund is not part of your estate. It's not subject to the terms of your will. Oh no, Professor Davies, when I die, I've left everything to my friend, my spouse, my children, whatever. That's not true. There are certain assets that do not form part of your estate, such as joint tenancy. Life insurance is payable to a third party, cross-owned insurance. So if you die, it goes to your husband. Another one is superannuation. Superannuation does not automatically go into your will when you die. You can get it in there. You can get it in there, but it doesn't automatically go in there. You've got to do something like a binding nomination, which is what we're doing today. There are many cases. Now, one of the reasons this is such a popular document is that many binding nominations do not work. Many binding nominations do not work. There are strict, and you should be using a law firm that specialises in superannuation. And here's one here. In this instance, you're meant to tick legal personal representative on the form, but they ticked my estate, which you thought would have been correct, but it's got to be legal person representative, and you've got the complaints tribunal saying this over and over again. Super is not controlled by your will. I've picked up just six cases which I found interesting, but there's numerous cases in Australia that proves that. If you put us to the test, and there's links, you can go back to, there's a High Court of Australia authority. Now, the next thing is, your self-managed super fund deed may not allow binding nominations. Well, this kit that you're now about to build is going to change the deed by a deed of variation of your self-managed super fund to allow for binding nominations. So if there's been mistakes made, I was reviewing a self-managed super fund, a brand new one, prepared by a non-law firm, which seems extraordinary, by a non-law firm, and it had that the binding nomination had to be in the terms of the second schedule of the self-managed super fund deed. And I looked to the second schedule, this is only recently, and it's only got one witness. You have to have two witnesses, that's obvious, because the legislation states it. So this self-managed super fund deed could never allow for a binding nomination because it has to be in the form of a second schedule, which only has one witness. So this kit, this binding nomination kit that you're building, will put in yet another variation, another deed of variation of your self-managed super fund to allow for binding nominations. What does it include? Well, our cover letter, the deed of variation to update the self-managed super fund, the death benefit agreement, you print that out, and if you've got 3 people who need it, your husband, wife and your third oldest child, you print it out 3 times and fill it out and sign it. And also an updated product disclosure statement which comes with it. Now, who gets my super at death is what we opened with, because that's one of the most important questions you can have. And here's the list of dependent. So it is your spouse and de facto, including same-sex couples, your children of any age, including adopted children. If you adopt a child, it becomes your child. If you lose a child through adoption, lose is a pretty strange word, but if you adopt your child out, then that child's no longer able to challenge your will and is not your child anymore at law. Biologically, yes, but not by law. Any person with an interdependency relationship with you, this is a grandson living with you, stripping you off, getting in the shower, cleaning your backside, getting you back into the bed, spoon feeding you, do whatever needs to be done. Interdependency relationship, spending 3 or 4 nights a week at our granddad's home. And then the other person is a legal person representative, which is highfalutin language, but it's the wording that has to be used, and that is, of course, if you have a will, it's the executor or executors named in your will. Now, if you have a 3-generation testamentary trust will to wash out that 32% tax on your super, then you will do a binding nomination to legal person representative, you tick the box, and your super is mandatorily required to go into your will, therefore it gets controlled under the Superannuation Testamentary Trust and washes out that 32%. There's the article on 32% tax on super, or links to it. This case is interesting. This is Munro & Munro, one of the first cases on this back in 2015, where the financial advisor, the accountant and the lawyer all agree you're meant to say the word my estate or my will, but it's not right. You've got to use legal person representative. How do I control my super when I die? There's the 3 ways which we discussed: the trust deed, the trustee's discretion, or binding nominations, in which case we're building that document now, or building the power to do non-lapsing binding death benefit nominations. There is some debate, but it's no longer a debate because the courts have now said it to be the case. But when I started practicing in 1988, we did not know the answer to whether we needed to have 2 witnesses or 1, and it's now clearly 2. There are things called 3 binding nominations which expire after 3 years, and that sadly is the fate of many retail funds. But we're not dealing with retail funds here, we're dealing with self-managed super funds which have between 1 and 6 members, and you run them yourself. They're self-managed, mum and dad run them. There's a case on a video on some of the failed messes, and it goes on and on and on, and there's all the court cases for you if you're so inclined. If you're an engineer or primary school teacher or some other anal retentive person, then you're welcome to, like myself. My wife's a primary school teacher. Please don't email my practice manager and complain that I said bad things about engineers and school teachers. If you need the more information, then you can just have a look at these different decisions and some of the direct lines from the court. Can a text message end a de facto relationship? Fascinating case. Obviously, if you get divorced or you separate or you enter into a relationship, before you ring up your mum and tell her the good news or bad news, telephone Legal Consolidated so we can update your documents to make sure that they're up to date. Stamp duty on these documents, and there's best practice for accountants, financial advisors. 5 things that we've noticed over the years from the court cases. Well, I'm excited. I can see there's as with all our documents, at the very top there is a free sample, and also a checklist as well, the questions we're going to ask. I'm ready to press the big green button. I'm going to start building the document. So with all our documents, you need to log in. You become a client of our law firm. You become a client of Legal Consolidated. So we just need to collect some data from you, your email address and your username. And some accountants have done 200 or 300 documents with us, so they might pick up data from an old document. But I will start this document afresh. So I put the name of the super fund in. And not necessarily the address of the super fund as it was when you started it 20 years ago, but just the current address and the date when the self-managed super fund started. Professor Davies, I don't know where that is. Well, let's have a look and see if there's a hint. And there it is. There we go, up here. There's some hints on binding nominations. I can't find the date. And there it is. There's another training course on helping you to find the date of the self-managed super fund. So whatever you need, we're here for you. It's normally the very first page or very last page of the signing. But if you get stuck, just telephone the law firm and the law firm will help you. Your super fund may have been updated recently. They're like motor vehicles. They need regular updating. Every time Labor gets in or Liberals get in, there's a change legislation. We need to change the trust deed. Great business for Legal Consolidated. And we are not after the current or last variation of self-managed super fund. We want the original one, which might have been back in 17th of December. I now have a green tick. I'm really excited with that because that means as far as Legal Consolidated is concerned, the logic flow is correct. So I could press members, but I'm not. I'm going to go and press next. If I press next and get to the next one, it means I've got a green tick. If you've got a big red tick, there's something you didn't answer. Oh, it's not true. Well, have a look. Oh, you're right, Professor Davies, as you always are. My wife doesn't agree with that, but as you often are, Professor Davies, you're right that I didn't complete the date or whatever. So let's get the name. So the first member is in Victoria. We could add a second member, but we won't. You can have up to 6 members of a self-managed super fund. And I'm going to press next. No, I'm going to press the trustee. I can see it's green ticks. Now, when you have a self-managed super fund, you've got to have either all the members being trustees, which is very uncommon these days. Normally you have a company as trustee, and the rule is, as you know, that if you've got 4 members to your self-managed super fund and you have a corporate trustee, as most of us do, then those 4 people have to be the directors, and only those 4 people must be the directors. So I have a company as trustee. Nominees, Pty Ltd, and Australian company numbers always have 9 digits. And the company's based in Queensland. Do we want the names of former trustees? No, we don't. There's a hint on that. I have a company as trustee. Well, good. 90% of you have, the 90% of self-managed super funds which are built on our law firm's website will have a company. So I've now got all the data I want for that question. I've answered everything. Good. And I've got a green tick, even more important. So I've got a green tick, and I have, let's say I'm an accountant with over 400 documents. I better put in the client name so I can find it again in years to come. I'm now going to go to summary, and magically lock and build has appeared, which means as far as Legal Consolidated is concerned, the logic flow is correct, but you need to correct and make sure that the data you've put in is correct. The spelling, there's no spelling errors in names, and the addresses are correct. And I can do that. I've got a summary here. I can print it out, give it to my client if I was an accountant, financial advisor or lawyer, or I can check it. Oh, look, the company no longer has the word nominee in it, so I better go back to that. That was removed many years ago. So it's Ceres and Mavis Proprietary Limited. What a name, what a company name. All right, I'm happy with that. I'm going to go next, next. And I'm correct. So now I'm going to press lock and build and start building the document. Or rather, pay for the document. So I'll put in my credit card details. And success! My credit card has gone through, it's been processed, and within 60 seconds the document's emailed to me, but I'm actually going to download it myself. It's emailed to the address which I gave it, and you can see all my documents there. So I have a binding nomination invoice, which is fine, good, thank you. I have the product disclosure statement, which is good. That will please my accountant and my auditor. But I want to see the self-managed super fund binding death benefit nomination. What does it look like? So, firstly, law firm's letterhead. The company is a client of the law firm. So if you're a financial advisor, accountant, lawyer, we're responsible for this document. So cover letter, how to sign it, make sure you're at 100% scale. It's a PDF, so you want to bring it to 100%. Just saying what needs to be done. Minutes. So the minutes of the trustee with the membership, which is just young James at the moment. And this is the deed of variation. So this amends the self-managed super fund deed so that you will be able to have binding death benefit non-lapsing nominations, so that you control, or rather your members of your super fund your self-managed super fund control where the super goes at death. So there's the words. The clause 3, and make sure that if you've got something happening, this grandfathers all the good things from your self-managed super fund deed. Don't want to make sure that any old pensions and things are reserved and protected. Or the additional powers in order to allow the binding nomination. That's the deed. Now we move to the beneficiary nomination. So this gives you information about what happens to super when you die. Can you nominate your friends? No, you can't. Have a read of that. And here it is. So you will tick, if you are going to leave everything into your 3-generation Treasury Trust will, if you're going to leave everything to your will, tick legal personal representative. Oh, Professor Davies, do I name? I've got 4 children, all 4 of the executors. No, you tick the box that says legal personal representative. Oh, but I've also got a super fund with Gold State and they do something different. I don't care what another super fund does. These are self-managed super funds. Every super fund, every retail and industry super fund has the power to do whatever they want to do. But with self-managed super funds, it's legal personal representative. If you've got a self-managed super fund, that's what you do. So you can do a non-binding nomination. You don't want to do that. No, it expires after 3 years. I don't know why we allow that. And that's what I want. Option 3, which is the death benefit binding nomination. So if you've got 4 people that want to do binding nominations, you print these sheets of paper out and you'll complete them 4 times. For that member 1, that member 2, that member 3, that member 4. And there's the witnessing and the declarations. So you have now successfully built your binding nomination for your self-managed super fund. You've taken control. Enjoy the free resources of this wonderful law firm website. It's designed to educate you. Please telephone the law firm if you need a hand, but start the building process first. Start the building process first because it's highly educational. And if you ring up with a question that's never been asked before, we'll include it as one of the hints. So enjoy these wonderful resources.